I'm going to pause it at 33 minutes and 30 seconds. Deputy, whose body camera footage is this? And it looks like there's an object in your right hand. Is that the weapon that you found?
Walk away from them. Why? No. But what was any indication that he couldn't have?
Cutting them loose though.
No. Your argument fails on itself, Mr. Starr. Court does call the case of People versus Lance Ford.
Good afternoon, Your Honor. Agreement to cook. Well,
Good afternoon, Your Honor. Phobia Star behalf, Mr. Cook, Mr. Cook, stand in 16. Mr. Ford. Yeah, I'm sorry. Mr. Ford. I said Mr. Cook. It's been a long day. Mr. Ford. State your name. I'm sorry.
No.
Mr. Cook is right there. I'm not.
Don't even. All right.
Your Honor, time set for preliminary examination. The people are ready to proceed. I do have some preliminary matters once the court's ready for those.
Okay.
Was it? Yeah, so that's what I was going to trust.
Oh.
So, Your Honor, before we begin, the current complaints alleges 2 counts, count 1 felonious assault, count 2 carrying a concealed weapon. I do not intend to proceed as to count 1, so we'll be proceeding just as to count 2, and I'll only be moving for bind over on that count 2 of carrying a concealed weapon. Additionally, I'm not sure if the defense plans on calling any witnesses. People have 1 witness. I would ask for mutual sequestration just in case.
I have no witnesses.
Witnesses are hereby ordered sequestered.
And then finally, there was an offer that was extended to waive up and plead to count 2 under HIDA. My understanding is the defendant does not wish to avail himself of this offer at this time and wants to hold his exam.
Wishes to hold his exam. He's eligible for HIDA with judicial consent. So I'm basically what I'm saying, we're not necessarily rejecting that, but he is asking to hold his exam. It's my understanding if it's found over, he can still ask the judge for HIDA because he's HIDA eligible.
But there would not be an agreement from the people to
that.
Certainly.
Correct.
All right. Proceed.
Being called Deputy Bryant.
Let's see. And if you would like the testimony you want to give, prove the whole case, not supposed to go together. They explain first and last name and record. First name is Kai, K-A-I. Last name Brian. You got Y kids.
All right. Thank you. You may proceed.
Thank you. Good afternoon. How are you doing? Doing just fine. Thank you for asking. Sir, how are you employed? How are you employed? And in what capacity do you work for the sheriff? How long have you been working as a deputy?
So,
any previous law enforcement experience? Where did you work before? How much law enforcement experience do you have? I want to turn your attention to June 9th of this year. Were you working for the sheriff on that day? At any point that day, were you dispatched to 1241 Stamford Court in Superior Township? What were you dispatched for? At any point that day, did you have contact with an individual by the name of Lance Ford? Do you see that individual in the courtroom today? Can you please point to them and identify them by an article of clothing that they're wearing?
black shirt.
Record may reflect this witness has identified the defendant.
That objection record shall so reflect.
Okay.
Where did you first have contact with the defendant on that day?
Inside.
And this unit, is this a house, an apartment? What sort of unit is it?
So, fine.
All right.
House.
How would you describe your initial interaction with the defendant?
I've never seen him. He was shaking, quite even nervous of our presence.
What was the course or purpose of your investigation?
I already found a figure out the situation. Talk about testimony.
And without getting too much into the details on that, what did you end up deciding to do between the parties?
So we decided it's best for the both parties.
And when you say both parties, who is that?
Anthony says,
What did you do then with the defendant?
we offered him
To where?
but he said his aunt's house down the road.
Why'd you offer him a ride?
That was not that. Yes. Felt like walking.
Where was that conversation about having a ride? Where did that conversation take place?
Pardon.
At that time or at any point, was the defendant ever detained?
Before that, I think was that
At that point, what, sorry?
wasn't asking for the ride. Before that, he wasn't.
How many officers or how many deputies were present when you offered the defendant a ride?
There were 4 deputies, 2 in the parking lot. 2.
Was the defendant handcuffed at that point? Were you surrounding the defendant? What happened when you offered the defendant a ride?
He accepted it.
Did the defendant verbally accept it or did he just sort of go with you? What specifically did he say? Do you remember? What did you do at that point?
We see the walk towards the patrol vehicle. One of the deputies asked him to hold the search the bag. I said that
Why did you feel the need to search the defendant's bag?
whenever we put a subject in the patrol vehicle search, like for courtesy advance, we'll search the bag.
Just for clarity first, did you order the defendant into your patrol car? Did any deputy or other law enforcement order the defendant into your car? Did the defendant allow you to search his bag? What did you find when you searched the defendant's bag? And for the record, what is that?
Let's see, the small subtle bag. Shared at 357.
Was the weapon loaded? Did you find any ammunition? Where? Where was that magazine? Do you have your body camera active while this was happening? Have you had an opportunity to review that body camera prior to testifying today? If you saw it, do you think you'd be able to recognize it? I'm going to plug myself in. If I can put up for authentication purposes, what's going to be marked as People's Proposed Exhibit 1 here. All right. And so for the record, there is a screenshot or a still from a video on the screen right now. Sir, do you recognize what this is from? What is this?
From
And is this recording a fair and accurate recording of what happened on the 9th of June?
everything in the parking lot.
Your Honor, people would move to admit with Mark's People's Proposed Exhibit number 1 into evidence.
No objection.
Exhibit 1 is admitted.
Thank you. Permission to publish, Your Honor?
Yes.
For the record, this is an hour, 15 minutes, and 4 seconds long. I'm going to be playing a short clip of it beginning at the 32-minute and 13-second mark. There is audio as well.
Yeah, no objection to that. That is the primary.
It's not that. It's down the street.
I'm gonna pause it at 33 minutes and 30 seconds. Deputy, whose body camera footage is this? And it looks like there's an object in your right hand. Is that the weapon that you found? All right. We can take me off, please. I'll leave it up so you can reference it, but we're just gonna take me off or something. Deputy, what did you do after you discovered the handgun?
We're therapies that were in the house.
If I can have just 1 second, please, Your Honor.
Yes.
I'll pass the witness at this time.
All right, cross-examination.
Oh, yeah, I can bring it up. Sorry, I didn't know you needed it right. Where do you want it from? The beginning or the 32?
If you could, is it 32 or 34?
32:14 is where.
Yes, 32:14. I may go a little bit back, but I'll announce it.
I pulled up where you want to be.
Okay, okay, Deputy Brian, correct? All right, good afternoon. My name's Attorney Trovia Star. I'm gonna ask you some questions this afternoon, okay? So, is it customary to offer a potential suspect or individual a ride in your car or any patrol car? From time, why time to time? Depends on what?
The conditions, it was hot that day.
Okay, so if it was extremely cold, you would give somebody a ride? If I told you one time I was stranded and it was extremely cold and I called the Washington County Sheriff's Office for a ride and they said, no, we don't do that. Would that sound right?
Jack speculation.
That's not speculation.
Are you saying that that's something that happened?
Yes.
Or are you saying, well, then there's going to be a lack of foundation unless, so.
I'm sorry.
Yeah. So yeah, I'm going to sustain the objection, but also there's a lack of foundation if it's something that actually happened.
Do you deny, or in your experience as a deputy with the Washington County Sheriff's Office, have you ever seen the Sheriff's Office deny someone a ride when they call under extreme weather?
Who didn't?
The Sheriff's Office, whoever the dispatch, yeah. No idea. Okay. All right. Let's get back to that day. Is your testimony that my client, Mr. Ford, was asked if he wanted a ride and he said yes, correct? Now, you're not allowed to force someone to get in your car, correct? You're not allowed to, if they say no, you got to come with us, correct? Okay.
You'll need to plug cable and plus the right hand side.
I'm now going to replay People's Exhibit.
Oh,
No, there you go. Okay. I'm going to now replay People's Exhibit number 1, except I am going to go back to 3150.
they want is, and they are the bottom behind.
Now, Isn't it true that you just heard Mr. Ford say, I'm not gonna have y'all take it?
So it sounds.
All right, so he didn't say yes to a ride.
It's to that point. Until he was asked by Roberts.
I'm going to resume playing at 32:20.
It's not that far. It is not by, Stevens. That was revised. SB 18. What was it?
Now, is that you saying we'll take you?
He answered saying yes to W. Roberts, to
And take them in terms of give them a ride, correct? Now, anytime someone gets in your vehicle, I believe you testified that you search their belongings, correct?
give a football search for stuff. We said I can walk this in.
Okay. One moment. Nothing further. All right, thank you. Redirect.
I have no redirect, Your Honor. Thank you.
All right, thank you. Sir, you may step down. Thank you. Additional witnesses for the people.
None, Your Honor.
None from the defense, yeah.
All right, do I have a motion?
Count people move for bind over as to count 2, carrying a concealed weapon. As people at the beginning, we're not moving for bind over on count 1, felonious assault. Done that today. I believe the court heard testimony and saw the video showing that defendant was all defended his bag towards the deputies after he was told that they would need to search it in order to give him that right. During a search of that bag, the deputy was uncovered, handgun concealed within that bag. Defendant certainly that bag on his person. The people have met the elements by. Ask this court to bind over to stand trial.
Fine.
There are 2 issues, but I'm going to focus on the first issue, which there's a clear consent issue here, Your Honor. Reviewing courts must determine on the basis of the totality of circumstances whether it has been freely given or has been coerced. Actual knowledge of the right to refuse consent is not essential for a search to be voluntary, and police therefore are not required to inform a person of his rights as the Fourth Amendment. But consent will not be regarded as voluntary when the officer asserts his official status and claim a right, and the occupant yields because of these factors. Those are cases of Amos versus the United States, 25 U.S. 313, 1921, Johnson versus United States 333, United States, U.S. 10, 1948, and lastly, Bumper versus North Carolina 391, U.S. 543, 1968. Your Honor, under the totality of circumstances, it's clear that my client yielded to the officer's directions. He said, I don't want you guys to take it. You guys don't have to take it. That's further conversation. You never hear him say, okay, you know what, you will take it. Instead, you hear the officer say, okay, we'll take you. Come with us. Come with us. Something along those lines. It's at that point where, again, as cited, the claim of right, the official status as a deputy saying, okay, we'll take you, even though I just said, I don't want you guys to take me. It's at that point where the lack of consent and the coercion is implied, because I just said, no, I don't want to go with you guys. Now you're saying, okay, we'll take it. What's the other option right there? You just said no.
Start walking towards Stevens Drive.
But see, that's the good point. Now, am I still under control of them? Can I leave? If I walk away from them,
But what was any indication that he couldn't have?
because, okay, we'll take it. If I walk away from him, when he just said, okay, I'll take you, when I just said, no, I don't want to go with him, there's two opposite spectrums right there. One side is saying, no, I'm not going to go. Another side is saying, okay, we'll take you. If you walk away, what does that imply? That I'm not following this person's
And you're saying that the act of him going from the place that they initially were over to the vehicle was involuntary or coerced in some way?
No, not prior to the statement of, hey, I don't want you guys to take. Prior to that, no issue. Come over, they talk. I believe they were informing him of a warrant, but that wasn't admitted as evidence. They're talking, and then the issue comes up about, as the deputies testify to, about whether or not we're going to drive you to this particular location or whether or not you're going to walk. It's clear. He says, I don't want you guys to take me. That should have been it. Any person any officer then saying something else such as, okay, come with us. Okay, we'll take you down.
When you're saying, okay, come with us, you're saying that the officer was saying that he had to go or indicating in some way? Because I'd like to see that on that tape where there's some indication that you have to come with us.
It would be this thing. If that's the situation, the onus would be on the person, the individual, to then say again, hey, I don't want to go with you guys. He already said it once. We're not disputing that. We're not disputing that he's saying, I don't want to go with you guys. So it sounds like he would have to say again, he would have to assert it over and over again. I'm not going with you guys. And he
doesn't keep changing the words because he doesn't say I'm not going.
He said, I don't want you guys to take me. He says, I don't.
They offer him a ride.
Right. And he says,
I don't want you to take me.
Right. And then the officer says, okay, we'll take you. So again,
at that point, you're saying that the officers did something to make him believe that he had to go?
Yes.
What was that?
By saying that we'll take you after I just said, I don't want to go. You guys don't have to take me. I mean, this is not me saying this. This is not an attorney saying, hey, after someone says, after I say to a person on the street, hey, do you want to ride? And say no. And you say, hey, are you sure? He didn't even say that. He said, okay, we'll take you. And again, we know that from his testimony.
So the purpose of the officers doing that was to do what?
As he stated, to try to search his. That's why I was getting it. We know that it's custom is if a person is inside the police car, that they search their property for safety reasons. This was
would the officers have been within their right, given the circumstances, to search his bag when he comes out with it and he's in the presence of the officers for the officer's safety?
No, not at that point, because the investigation had wrapped up. And now there's a discussion about some type of warrant, and it's over with now.
Yeah, but at some point, and I'd like to know, you're asking me to make a determination based on only certain pieces, right? Because when you say there's a discussion about a warrant, what's that discussion?
It's from the audio, it sounded as though the discussion was, yeah, go take care of it, and that's it.
That he has a warrant.
And then it transformed to, okay, whether or not you want to ride. Again, I'll just say this point clearly. My client said, you guys don't have to take it. It almost sounds like he has to say that again. That, hey, no, after the officer says, we'll take you after he declined, it sounds like he has to say it again. In order for it to be.
Or not go.
Or that's now if you say okay or not go, now it's like okay, his words are ambiguous when he says you guys don't have to take it. If a police officer asks,
I'm not arguing that they forced him into that vehicle.
That's where it's exciting in the case. We're talking about an appearance of an official status, right? This is a police.
What did the officers do from the time that he's at the side of the one vehicle and heading over to the other vehicle that made him go to that other vehicle?
Did not adhere to my client's statement of.
No. But they didn't move his legs, right?
You don't have to force someone to do anything with coercion. You can verbally say, no, that's okay, we're not going to do that. Again, that's what we're talking about.
Sorry. From the point that he's at the side of the vehicle talking to, I think that was Roberts, right? To the point that he goes to the other vehicle. What did the officers do that made him go to the other vehicle?
Statement of, yes, we will take you.
That's what the officers did.
Yes, the statement of, yes, we will take you. When he just said, I don't want you guys to go.
I hear what you're saying in terms of what was said. But all of that is said at the one vehicle. What coerces, because you're saying that the officer somehow coerced him to go from that one vehicle to the other vehicle? What did the officers do? They didn't surround him and kind of force him that way. As I see the tape, there are officers in the area, but they're not surrounding him. So what you're saying, it was the officer's statement of "we'll take you" that made your client go from that one vehicle to the other.
After he said, I don't want you guys to take it. That's where we start talking about official status. This person with an official status as a law enforcement officer, after I told him, after I denied his offer, is now saying, okay, we'll still take you. Again, it sounds as though like we're saying that's not enough for the person in that situation to decline the offer. It sounds like we're saying there has to be more. There has to be more, such as, oh, you walk away and then they grab you and say, no, you got to come with us. Or, no, you have to come with us. It sounds like there has to be more than just simply declining the offer. Under normal circumstances, when the police are talking to anyone, when they're interrogating anyone, the moment someone declines, that's supposed to be it. It's supposed to stop right there. There's not supposed to be anything after that.
So the officers shouldn't engage citizens after that? I guess I'm still not understanding the point. What?
If you decline, yes, that's where we're talking about the official status comes into play. Because if you're declining an officer's request and then they still say, hey, come with us, we'll take you.
But hold on, they're not saying come with us, we'll take you.
Yes.
To which he can say what?
So you say what? Say it again. You have to say it again.
No,
I don't want to go.
No, I got it. That's all right. And just start walking on.
Again, I'm not disputing that, but that's my point. It sounds like there's more. He has to do it again, which under normal circumstances, that's not the case. That's what
Sir, you've never been in a situation where somebody offers you something, you say no, and then they say something to you, and then you change your mind.
That was my example in terms of me as an attorney offering someone as a ride. And I say, are you sure? Are you sure? Here, the problem is we're talking about a law enforcement official, and that's what we're talking about as the case.
So all of this, by your argument, was sort of a pretext for those officers to search the bag.
Yes. He said anytime someone.
But hold it. They really wanted to search the bag, and be careful on your answer. They can search that bag based upon the fact they know he's got a warrant.
They're cutting him loose, though.
No. But they could, if they wanted to, listen to what I'm saying. If they wanted to search the bag, that was this deputy's sole intent in life at that moment, that they want to get into that bag. They have the ability to do it.
And they didn't.
before that point.
They didn't. Because
That wasn't their intent to get in that bag. Your argument fails on itself, Mr. Starr, because if they wanted in the bag, all that, then there's no question whatsoever of anything. What you're then saying is all of a sudden they're at that point and now they're going to create some ruse to try to give him a ride for the sole purpose of searching the bag when they could have done it 5 minutes ago or whenever.
one point about the warrant. It all depends on when they discover whether or not they're going to arrest him for the warrant. If they're going to arrest him for the warrant, yes, absolutely, they can search that bag all day long. But if it's a cut and release, like it appeared to be, they're not going to search the bag.
The deputy testified that at some point your client's detained by them. If they wanted in the bag, they could get in the bag at the point of detention. That's where your argument makes no sense to me. That then after that point, they have to create some ruse to get into the bag. I don't think your interpretation, maybe others that disagree, your interpretation of that conversation that took place between that individual and the officer led to some type of coercion or lack of consent. Those officers did not move your client's feet from that one vehicle to the next vehicle. I didn't see the officer saying or grabbing that bag out of your client's hand. I didn't see them put him in cuffs till after they discovered the weapon. None of that. Is there anything else?
That's like I said, it has to be more. I understand the court.
Like your argument should be more. Anything else regarding your argument? Anything else regarding your argument?
I respect my argument. That's all I'm saying.
Anything from the people?
No, Your Honor.
Court has listened to the testimony in case the defendant is charged with the carrying of concealed weapon. It wasn't even necessarily of an issue of consent, but to the extent one has to do, there was nothing that the court sees in the video or anything along those lines where these officers were taking away this individual's ability to consent, or that in some way and or another coerced him either to go to the vehicle to accept their ride or to coerce him into the search of the bag. I would further state that, and just to repeat this as part of my decision, the argument of defense in this court's mind is illogical. If the officers or deputies wish to get into that bag, there are points at which they could have certainly done that and legally done that. They could have done it at the point of detention. They could have done it the point of potentially an arrest on the warrant. They don't arrest him on the warrant. They offer him a ride. He initially may decline that ride. They indicate that they'll take him over to Stevens Drive. He goes with them over to the vehicle and does that. I don't think you can sit there in this court's mind and sort of blame the officers that what they're doing is that they're somehow flashing their authority to force him to do anything from that point. Defense admits that he is released at that point. He didn't have to do anything. He could start walking towards Stevens. So, given I think that argument fails, it is clear from the testimony in this case that the defendant was carrying a weapon concealed within the bag or the knapsack, whatever one wants to call it. The people have sustained their burden. The defendant will be bound over to stand trial and carry a concealed weapon. Count 1 is dismissed. As to the information, Mr. Starr.
We stand mute with.
But in every way from a reading standing mute, the court will enter a not guilty plea as to count 2. Pretrial in this matter will be set
September 17th at 1:30 with Judge Slade.
September 17th, 2026, 1:30 for Judge Slay. Bond will continue. Thank you.
Information prepared and filed with the court.
Thank you.
Have a good day, Your Honor.
Take care.
The hearing took a significant turn when the court focused on whether the defendant voluntarily agreed to go with deputies and allow a search of his bag. The defense argued that his words showed he had declined the offer, suggesting that the officer's authority influenced what happened next. But the judge closely examined the body camera footage and questioned whether there was any actual pressure or force involved. The court ultimately found the defense argument unpersuasive, noting that the defendant was not physically forced into the vehicle and that the officers had other legal options if their goal had simply been to search the bag. Based on the testimony and video evidence, the judge concluded that the prosecution had presented enough evidence to move the concealed weapon charge forward. The assault count was dismissed, while the remaining charge was bound over for trial.